On Wednesday, July 10th, the Alec Baldwin trial kicked off in Santa Fe, New Mexico with opening statements. If you don't know much about this case, check out my primer video on the basic allegations and the arguments in the case. It is linked down in the description below of this very video. Anyway, on day one, what we got from the very outset of this trial was two very different ways of viewing not only the incident itself, but kind of the world in general. What became very clear to me personally early on day one is that this case isn't so likely to come down so much to the facts of what happened. Rather, this may end up being more about philosophy. If you play pretend with something that has actual real-life consequences, can you be held responsible? Put another way, are there rules about firearm safety the same for everyone regardless of context? Or is there a distinction to be made on a movie set where the magic of movie making essentially requires that those responsibilities on set be divided into a more bureaucratic kind of way, where safety employees worry about safety and the artists on set can worry about their art? Because of these questions, this actually may end up being a bit more of a complicated discussion for the jury than the Hannah Gutierrez-Reed case was, where her job was actually safety. She was the armorer on set after all, as opposed to Baldwin's job, which was in fact art. And so one of the main questions here is, does an artist still nonetheless bear some responsibility for safety when they are doing their art under certain circumstances? I honestly don't know at the outset how the jury is going to decide on this one, and I'm very interested to find out. Let's get into it. Okay, to start off, just to give an overall picture of what day one was all about, the jury first heard opening statements for both sides, and then they heard from the state's first 4 witnesses, all of them from either the Santa Fe PD or the Santa Fe County Sheriff's Department. So let's start with the opening statements. So to begin, I always like to at least touch on what opening statements are and what's supposed to happen in them. In other words, what should we be looking for here? First off, they are called opening statements, not opening arguments. And this is because the attorneys are actually not allowed to argue in their openings. And that in turn is because in order to be able to make arguments to the jury, the attorney's arguments have to be bound to the evidence presented. And at the very beginning of trial, no evidence has yet been presented to the jury. So therefore, no arguments are allowed either. So then what is the purpose of the opening statement then? It's to give the jury a framework and a roadmap for what they are going to be seeing unfolding in front of them. Both sides are going to want to give the jury their main points. Where's the controversy here, and where do the sides disagree on what happened and what should result in the courtroom? This helps the jury to essentially build their own filing system for all of the information that they are about to be inundated with in the days, maybe even weeks to come. And so a successful opening statement is going to make it very clear what the legal team is going to be arguing at the end, and importantly, it will also flag for the jury what they're going to need to particularly focus on during the days and weeks that follow. This is not the time to be throwing facts and data at the jury because they are coming in so fresh that there's no way for them to be able to remember details like dates and times and names or any kind of like really technical information. Instead, the best opening statements are the ones that are concise, to the point, and allow for the jury to expand the scope of their focus as they continue to learn more about the details of the case through the testimony during the trial. And both sides would also do well in the opening statements to establish essentially their own theme, ideally with some kind of buzzwords that can be drawn out and referenced in the testimony to come. But a word of caution about the opening statement. Having a very dramatic one can be exceptionally powerful because it can naturally take the jury's attention away from the other side and lead them to build a framework of the evidence that's more beneficial to your side. However, an opening statement is also a bill of promises, and at the end of closing arguments, the jury is going to decide whether those promises were kept. So attorneys also have to be careful with an opening statement so that they don't overplay their hand, so to speak, because juries tend to be pretty good at seeing when they've done that. Okay, so that's the opening statement in a nutshell. How did it play out here? The jury first heard from the state, and this is because the state bears all of the burden of proof here. Remember, the state of New Mexico has to prove beyond reasonable doubt that Alec Baldwin is guilty of involuntary manslaughter for the death of Halyna Hutchins. So this means that in most jurisdictions, the prosecution is going to go first, the defense will go second, and if the prosecution reserves some time for it, they can do a rebuttal to respond to the defense. It is much more common to see a rebuttal on closing arguments as opposed to opening statements, since the state has an entire trial in which they can respond to the other side. But it is very likely that when we do get to closing arguments at the end, we will see some significant rebuttal time by the prosecution. Anyway, the opening statement for the prosecution was delivered by Special Prosecutor Erlinda Johnson. I have to say, in the first Rust trial, the trial against the armorer Hannah Gutierrez-Reed, there was a different special prosecutor that was aiding the lead attorney Carrie Morrissey and who also delivered the opening statements for the prosecution. And already, I think Miss Johnson is definitely an improvement. Personally, if we're talking about preferences over attorney style, I have to say, I think that Miss Johnson so far is my favorite attorney in this particular trial. The other two attorneys that we saw on day one already showed a lot of spice that quickly turned into snark, and so there were some courtroom theatrics that to me really started to feel like they were going for sometimes flash over substance. And this is not a prosecution versus defense kind of thing, because the other two attorneys I'm talking about were from both sides. People are obviously free to disagree with me as always, but this is just my impression so far. And don't get me wrong, I love some good courtroom spice. I became a huge fan of Alan Jackson during the Karen Reed trial, but there was something about both his charisma and his trial skills that made me enjoy when he did bring the spice. Anyway, all of that is to say that in comparison, especially to the other attorneys that we saw on day one, Erlinda Johnson just came across as refreshingly straightforward, and yet at the same time also as a human as opposed to some unemotional lawyer robot, which is the other way that the pendulum can also swing. And this all was true also in her opening statement. She delivered a well-planned, well-organized opening statement that was concise and clear. She went into some of the details of the case, but for the most part kept it really down to the brass tacks. And here was her main point for the jury to frame this whole case. She said essentially that Alec Baldwin was playing make-believe with a real-life firearm, and in the process he violated the cardinal rules of firearm safety. So essentially, even if you are using a firearm as a prop on a movie set, the rules of firearm safety are still the rules of firearm safety, and you can't ignore them just because you are playing pretend. And one of the main themes that she drew out here, which I think is going to get repeated throughout this entire trial, is that Alec Baldwin would do what Alec Baldwin wanted to do. People would give him instructions, but then he would do his own thing anyway. According to the prosecution, this included railroading inexperienced employees hired for the film's production, including the armorer. And it also included mishandling the gun throughout production. The prosecution said that the jury would see how he was doing things like taking the firearm in his hand between takes and using it as a pointer to point all over the place. Then there were things he was doing like cocking the gun when he wasn't supposed to and putting his finger on the trigger when he wasn't supposed to. And Johnson also pointed out that even for a movie set, there are safety rules. And those rules include treating every firearm as if it's loaded, never pulling the trigger, and never pointing it at anything that the gun holder doesn't intend to shoot. Now, to round out this opening statement, Johnson also made a couple important points basically to answer questions before they popped up for the jury. And those were, was there anything wrong with the firearm to make it go off on its own, perhaps? And was there any other indication that something like this could happen before the incident actually happened? For the second question, obviously, this is answered partly with the reference to Baldwin's overall alleged carelessness with the firearm throughout the production. But it's also answered with Johnson's reference to the fact that the camera crew had walked off set earlier that day before Halyna Hutchins was shot. And according to Johnson, the jury is going to hear testimony that one of the big reasons they walked off was because of their concerns over firearm safety on set. Of course, one of the things that the jury is still going to need to determine, even with those kinds of points, is whether Baldwin had any responsibility related to those other safety concerns. This could be something that does backfire on the prosecution. After all, if the jury ends up concluding, well, yeah, there were major issues on set, but that was much bigger than Baldwin, and he was just fortunate enough to not become a victim himself. Anyway, then there's the other issue. What was the condition of the firearm itself? Was it malfunctioning, for example? There definitely is going to be some strong fighting between the legal teams over this particular question, but the firearm was in fact tested to see if it was in working order. And according to Johnson, in her opening statement, she said that there was rigorous testing that ultimately concluded it had been working just fine and could not have fired but for Alec Baldwin pulling the trigger. So overall, my opinion is this is basically everything that you want to see in an opening statement. There's enough detail in it to give the jury an idea of what to look out for, but not so much that their brains get quickly overfilled with disorganized pieces of data. So that's the state's opening. How did the defense do? I will admit, I had some fairly high expectations of this defense team, given their high-profile nature and the strength of a lot of their statements and arguments both to the press and in their legal filings. And these are big law attorneys with significant trial experience behind them as well. And so when Alex Spiro, the lead attorney for the defense, who is a New York big law attorney, got up to deliver the defense's opening statement, I anticipated a lot of firepower. And in the end, what we actually got was a bit more of a mixed bag. On the negative side, it did start to drag on a bit when it could have and should have been more concise. And this was especially true as Spiro started to get lost in the weeds a bit of some of the details, especially towards the end. He seemed to have lost his thread a few times throughout and also started to cross the line into making argument in his opening statement, which did draw some valid objections which were sustained. But on the plus side, I do think that he did do a good job of reframing how the jury should look at this case on a more philosophical level. Basically, he said, cardinal rules are not cardinal rules on a movie set. And I will say this kind of an argument can definitely cut both ways. Either the jury can walk away at the end of this trial feeling like they've just learned a thing or two about film production, and that can help them conclude that, yeah, there is a difference when something like this happens on a movie set. Or the jury may just end up looking at Alec Baldwin and saying, dude, I don't care how important you think you are in Hollywood. You do not get to have your own set of rules just because you live in La La Land. And so here in the opening statement, it really is important for the defense to give a good reason for why there should be a separate standard for movie sets. It can't just be because Hollywood is just different from everyone else, because that is going to play right into a potential bias that some of these jurors could very well have against Hollywood celebrities like Alec Baldwin, who also, by the way, already doesn't have the best celebrity reputation to begin with. So, how did Spiro go about this? Well, he actually started with what everyone is familiar with, movies. And this is fairly clever because we all understand what it is to watch a really good movie that transports us into a different world in the process. And obviously, that whole experience involves suspending reality for a bit to allow for the magic of movie making. And smartly, Spiro referenced classics that everyone is likely familiar with, at least on some kind of a level. He basically said it's the magic of movie making that makes the impossible possible. It's how King Kong exists and how Superman can fly and how we can get grand movies like Spartacus. And he said that in order for that movie magic to happen, movie sets have certain requirements. And with that, there often are real dangers that will get involved in that process. He said that the stuntman must leap and the snake must hiss. And in order for the movie viewer of films like Platoon and Apocalypse Now to experience the horrors of war without actually living those horrors, certain things do have to happen on a movie set that otherwise would be totally impermissible elsewhere. For example, you need explosions. You also need actors to point guns at one another. And so there developed this distinction in Spiro's opening statement between those people on set that are responsible for safety and those that are responsible for art. For the defense, there is a clear delineation in those responsibilities, and they can't mesh if we want to keep the magic of movie making. These people do their job, and those people do theirs. And so according to the defense, an actor has to be able to rely on all of these safety employees to do their job so that the actor can do their art. For example, if one of the crew responsible for safety hands an actor a firearm and tells the actor it is a cold gun, meaning it's inert, then the actor can't spend time thinking about whether or not that's actually correct. They have to be able to trust the people around them to do their job. Now, this opening statement didn't quite go so far as to write a love letter to movie making, but I will admit there was a part of me that half expected Damien Chazelle to walk into the courtroom and direct a whole colorful song and dance about the romance of making movies. But one thing that Spiro did say that I thought was pretty clever was he said that guns are in movies too, because movies are about people's lives and guns are in people's lives as well. And this was an interesting bridge between the tinsel world of Hollywood and the real world of firearms. Put another way, this is a way for Spiro to try to establish a sense of familiarity for anyone who is a juror that is familiar with guns, to get that familiarity with the world of Hollywood and what Hollywood is trying to do. In another sense, it was a way of trying to bring that distant world of Hollywood just a little bit closer to these people who live in Santa Fe County, New Mexico. But then again, maybe all of this did nothing for this jury. Maybe this jury is still gonna look at Spiro at the end of all of this and say, yeah, okay, that's all great and nice and whatnot, but like safety is still a very real thing. Like, yeah, please come back to Earth already. And I will say, one thing that the defense is going to need to press on the jury for success in their whole argument in this trial is the idea that Hollywood isn't actually as superfluous as most people think it is, and that movies actually serve a valuable function in society. It is very easy to just write off Hollywood as this world of elites who just live in their own bubble and expect to live by their own rules separate and apart from the rest of us, and who don't actually understand the everyday person's experience and yet are more than willing to lecture those people on how they should think and live their lives. And don't get me wrong, there is plenty of that to go around for sure. And for all we know, like I said before, the jurors might have their own biases against Hollywood in general, even if those biases are not strong enough for the jurors to say they can't be fair and impartial here. So in my opinion, in order to rein that possibility in, the defense would probably do very well to bring the societal value of movie making and storytelling to the forefront from time to time so that the jury is a little more likely to say, yes, Hollywood is unique and there's good reason for why they should be a different standard for this particular issue. Because at the end of the day, that is most likely what this whole case is going to come down to. Does the jury agree with the philosophy of the defense, or are they more likely to agree with the philosophy of the prosecution, which is a bit more centered and grounded in just basic realism? Now, before we turn to the testimony of day one, I will say that Spiro also pointed in his opening statement to a couple other things here that are essentially low-hanging fruit for any criminal defense team. And those were the quality of the investigation, the questions about where those live rounds came from, and the quality of the firearms testing to see whether or not the firearm actually malfunctioned or not. First, any criminal defense team is going to try to do what they can to introduce doubt about the quality of the criminal investigation by the police, regardless of whether there are red Solo cups involved for gathering blood evidence or whether it actually was a perfectly competent investigation with no real issues. And so here in this particular case, Spiro actually rightly pointed to some issues that the police had in investigating this case. Those were things like a bit of a failure to secure the crime scene as well as they could or maybe should have, and failing to separate the witnesses and keeping them from talking with one another before they gave a statement to the police. And I will say, there are potential issues that can point to problems with the reliability of this investigation. They're not as bad as we've seen in some other trials, but they do exist. But like I said before, this case isn't like some others where it comes down to proving whether one person really did something with, say, forensics. That was a bit more of a factor in the Rust Armorer trial, the Hannah Gutierrez-Reed trial, where the question of how those rounds got on set and then into the revolver that killed Miss Hutchins was a bit more of a factor. Here, it's definitely worth noting and talking about, but it's not really the thing that's going to make or break Baldwin's case, in my opinion. Anyway, next, the defense also made reference to that question about how the live rounds got on set. And this really is one area where I personally look a little bit more skeptically at the defense. In this case, no one is suggesting that Alec Baldwin had anything to do with how those live rounds made it on set. The real question here is whether he did what an actor is supposed to do for his role in the safety on set. And so to me personally, this whole question of how the rounds got onto this set feels a bit like a red herring put up by the defense to try to distract the jury from the main issues here. But anyway, then there's the final thing that Spiro criticized, and that is the firearms testing that the prosecution also referenced in their opening statement. But here, Spiro told the jury that they would see evidence that would show them that this was totally mishandled and that there were better tests that they could have done that wouldn't have damaged the firearm in the way that they ended up damaging this firearm through the testing that they did on it. And this again was to suggest to the jury that the police didn't do what they should have done to properly investigate this case. But this part does have a little bit more relevance to Baldwin's case because it introduces to the jury the possibility that maybe the firearm went off not because Baldwin actually pulled the trigger, but because it malfunctioned. So even though I personally did see experts testifying on this specific issue in the first Rust film trial, the one for Hannah Gutierrez-Reed, the armorer, I'll be interested to see if Baldwin's defense produces experts that help the defense case a bit more in this trial. Okay, so that's it for the opening statements. Then the jury saw the first witness of the day and the first witness of this trial. This was Officer Nicholas LeFleur. He is an officer with the Santa Fe Police Department, and he was one of the first responders to arrive on scene on October 21st, 2021. I will say he didn't feel like the most ideal witness to start out with, and it was really just because of his courtroom presence. He spoke really low and just seemed overall like he really didn't want to be there. And I will say that is often fair because trials can be very intimidating for any witness, and especially so in high-profile trials. But then again, he is also testifying as a professional here, so I'd expect a little bit more out of someone like him than, say, like a random bystander who happened to be there at the incident. But anyway, the state called him for a few reasons. This was to first give the jury basic information about what happened during the incident at hand, and to give the jury a strong picture of the overall scene, especially through body cam footage, and to place the high stakes of the case in the jury's mind so that they have a clear understanding of the reality of the fact that someone actually died during this incident. And one thing that the prosecution actually got to fairly quickly was some of the problems that occurred with the investigation. This was, for example, the fact that they struggled a bit with securing the crime scene at first. And the reason for doing this was for the prosecution to get a jump on the quote-unquote bad facts and to try to take the sting out of them. And I think that the prosecution honestly did a pretty good job of it. As Officer LeFleur explained, there were over 100 people there, and this was kind of a remote location, so the police response was a bit limited. This was a totally unique kind of situation for them, and this made it all harder to corral this large mass of people and to take control of the scene. And what's more, the impression that I got from this witness is that he was fairly new to the job, and particularly so when the incident actually happened. But there was another benefit to the prosecution for being the ones to bring up these particular issues. And this was the fact that Officer LeFleur's body cam footage picked up the group of witnesses from inside the church who actually kept talking to one another before they gave the police any sort of statements. And this included Alec Baldwin. Officer LeFleur testified that he had instructed Baldwin not to talk since they needed to get everyone's statements first. And this is all really to prevent any sort of a situation where the witnesses are lighting up their testimony, of course. But this bit ended up benefiting the prosecution a bit because it allowed them to reference back to one of their themes from their opening statement. And that is that Alec Baldwin is going to do what Alec Baldwin wants to do, regardless of how he's instructed by any sort of an authority figure. However, on cross-examination, the defense did rightly point out that there was nothing in that body cam footage that showed Officer LeFleur actually reinforcing that initial command to Baldwin. It's not like there's a few times where he's reminding Baldwin, hey, I told you not to talk, please don't talk. And I will say, on a human level, it is hard to criticize these witnesses for talking about something that clearly was very shocking and traumatic. And any human being is going to want to talk about it even just to process the event. And that also includes Alec Baldwin. Now, another thing the defense did well here was that they introduced into evidence a portion of the 911 call that was made on October 21st, 2021. And this was helpful to Baldwin, particularly because the person who made the 911 call also had some choice words for David Hall, the first assistant director, and she said that he was the one that was responsible for the safety of the firearm.
Is the 911 what's the location of your emergency? We need an ambulance out at Bonanza Creek Ranch right now. We've had 2 people shot on a movie set accidentally.
You said someone was shot?
2 people accidentally with gunshots at on movie set, Bonanza Creek Ranch.
Okay, give me 1 second. I'll connect you with medical dispatcher. Don't hang up. Santa Fe Fire and EMS, what's the location of the emergency?
Bonanza Creek Ranch has had 2 people accidentally shot on a movie set by a prop gun. We need help immediately. Okay? But this fucking AD that yelled at me at lunch because asking about revisions, this motherfucker. Did you see him lean over my table and yell at me? He's supposed to check the guns. He's responsible for what happened.
Now, Mimi?
No. I'm a script supervisor.
How many people were injured?
2 that I know of. I was sitting, we were rehearsing, and it went off, and I ran out.
Okay. You heard some language, and then that he, the first assistant, was supposed to check the gun. Did you hear that?
Yes.
Okay. Did you hear anybody on the 911 call mention Alec Baldwin at all?
No.
But Also on cross-examination, the defense then made what I see as a very large blunder. Alex Spiro really wanted to make a point that Officer LeFleur's testimony had changed over time, particularly in how he characterized the incident. It seemed to be very important to Spiro that the jury understand that Officer LeFleur previously called this incident an accident, a number of times even, and that now, when he's testifying against Alec Baldwin, he's conveniently changing his tune. To me, personally, this point doesn't really move the needle all that much, because at the end of the day, that is up to the jury to decide. And more importantly, there's no allegation that Baldwin purposefully caused this incident to happen. Rather, what we're talking about here is whether Baldwin was reckless or criminally negligent. Did he, at the very least, do something that a reasonable person would know was substantially increasing the risk of serious bodily harm to another person? This can be an accident at the same time that Baldwin was criminally negligent or reckless. But anyway, Spiro tried unsuccessfully to impeach Officer LeFleur with some prior testimony, then to refresh his recollection, and it all got a little clunky and confusing, to be honest. And like I said, to me, this felt like a lot of effort where the juice wasn't even really worth the squeeze. But then, after the lunch break, the defense admitted as an exhibit essentially the dispatch log for that day. And Spiro basically just sort of flashed it quickly in front of the jury without too much explanation of what this document was or the context of this document, and he basically just had the witness point out that at several points on this document it said accident, accident, accident. I remember thinking, okay, so he finally got this witness to say the words accident. It didn't really feel like a huge win when that came out, but okay, he wanted to make his point. But the problem is, then it turned into a huge problem for the defense when Special Prosecutor Carrie Morrissey got up on redirect to tear that presentation to shreds. That's because, as it turned out, this activity log wasn't just for police responses to the Rust film shooting. It also was for a bunch of different incidents that the police were responding to all day.
At the top of the page, do you see number 16? And there's a 16, and then there's a parentheses?
Yes.
What does it say?
Posted speed limit and actual.
What does posted speed limit and actual have to do with this incident?
I'm not too sure. It looks like the individual who ran it, their name, I don't know who that is.
Well, that's okay. Does this have anything to do with the incident involving Ms. Hutchins?
No.
So I want to take you down here to number 5, parentheses. What does that say?
It says non-commercial class, code D.
What is that person talking about? Does it have anything to do with the shooting of Ms. Hutchins?
No, that's the return. It came back for a driver's license, it appears.
That's the return that came back for a driver's license? Is that what you said?
That's what it appears like, yes.
Let's go down to number 10. Do you see that?
Yes.
What does that say?
Accident quantity.
Keep reading.
3, withdrawal. It looks like it's going to try to say withdrawal.
Does that have anything to do with this incident?
No.
And look, I want you to look down here at number 21. Do you see that?
Yes.
What does that say?
Of alcohol or drugs.
That you're aware of? Does that have anything to do with this incident?
No.
Let's jump down to number 26. 6. What does that say?
Objection, relevance cumulative.
Go ahead, sir.
Says drinking and driving at .0.
Did you read it all?
Yeah, per se, I think that's what it's saying at the beginning. Dash drinking and driving at .0. I think the next line is the blood alcohol content, BAC.
Were you dispatched to a DWI?
No.
And so this told the jury that the accident, which was pointed out by the defense, wasn't even really from the Rust incident. It was very likely from other stuff that police responded to all that day. And the thing is, you never want to have the jury feeling like you as the attorney are being too slick and trying to pull a fast one on them. So this was potentially an early eye-opener for the jury that maybe they can't trust the defense when they are putting something in front of them. And that is not a great start for the defense, in my opinion. But now the defense tried to ask for a re-cross-examination to address that activity log and to address the stuff that came up on redirect. And it sounded like he wanted to bring in to focus one more page that maybe would show that at least one of these accidents did in fact come from the Rust film set. But the judge did not allow it. And that's because this courtroom is very picky about how many times they allow the attorneys to go back and forth with a witness. This was something that was present in the Rust Armorer trial, where every witness had a direct examination, a cross-examination, and a redirect, and only under some very, very, very limited circumstances did the judge allow a recross. This is just how Judge Mary Marlowe Summers runs her courtroom, and this was known to both sides from the get-go. And I will say, it is well within her rights to run her courtroom in this way. How she runs the courtroom, procedurally speaking, is totally within her discretion, and it's the job of the attorneys to set themselves up accordingly so that they can succeed within those rules. So I do have a sneaking suspicion that Spyro may have legitimately had good, accurate information in whatever he wanted to recross on. But the problem is he lost that opportunity by not making things clearer about that activity log on his cross-examination when he initially introduced it himself. So it could be that he takes another opportunity with another witness to address this activity log again and to make the point that he wanted to make. And I imagine that if it's important enough to the defense to do so, we will see what exactly it was that he wanted to talk about. But if we don't, then I'll say that this was a very successful moment for the prosecution and a big blunder for the defense. Okay, so the state's second witness was Timoteo Benavidez of the Santa Fe Police Department. He was another officer who arrived on scene on October 21st, 2021, although he arrived a little bit later than Officer LeFleur. His testimony had a bit of overlap with Officer LeFleur's, as he also had some body cam footage that gave the jury a sense of what was happening that day. And he did testify that there were something like 200 people on set when he arrived, and also that this presented some challenges for their investigation. But his testimony focused a little bit more on the actual evidence gathering on the scene. One of the first things that he said that he did was to try to find the prop guy or the armorer so that he could find the gun that was involved in the incident. And so in the courtroom, the prosecution entered into evidence the revolver that was involved. He said that when he received it from the armorer, he checked it for rounds in the chamber and found that it was empty. He also checked the prop cart, which did appear to be extremely disorganized, and he overall said that this whole place was a huge mess. And he said that he found some rounds on the prop cart and collected those with the evidence. In the end, he seized the revolver and a bunch of ammunition that he ended up handing over to the crime scene technician for gathering and processing, and we will be hearing from her later in day one as well. Okay, so the state's third witness was Detective Joseph Lujan from the Santa Fe County Sheriff's Department. Now, his testimony was like the shortest that I've ever seen. The prosecution didn't waste any of the jury's time by getting extra fluff storyline from him. And so their only purpose for calling him was to have him explain to the jury that after the incident, he went to the hospital where Joel Souza was being operated on, and he collected the projectile that was taken out of Souza's shoulder/back and gathered it and documented it with all of the other evidence. This was just testimony about chain of custody. That's it. Simple, straightforward. And if you watched the Karen Reed trial with us before, you might find this testimony incredibly refreshing, even if a little bit boring. And look, when the police do what they are supposed to do, it is admittedly boring, but arguably that's exactly the way it should be. Anyway, Detective Lujan said that when he collected the projectile to join the rest of the evidence, he said he handed it off to Marissa Poppell, the crime scene technician at the Santa Fe County Sheriff's Department. And so naturally, she was the state's next witness. Miss Poppell was the one who took all of the photos of the crime scene, the surroundings, and the actual pieces of evidence. And so the jury got to see a bunch of these photos as she testified to show that absolutely everything was documented the way that it should be. And I will say, again, after the Karen Reed trial, the competence of Miss Poppell's work and her testimony was incredibly refreshing. And there was another aspect of her testimony that was extremely beneficial to the prosecution's case. And this was the fact that Miss Poppell also served in the role of educating the jury about dummy rounds and blanks and live rounds and how to tell the difference between them. I will say this was a great example of both a witness and an attorney doing a very good job of producing dialogue that allows the jury to clearly follow and understand what otherwise is very technical information. And this is the kind of thing that allows the jury to learn something that is important to the case.
Can you explain to the ladies and gentlemen of the jury what a dummy round is?
A dummy round is essentially ammunition that is not designed to fire a projectile. It is ammunition that's made distinct by either a hole being drilled through the side of it, so it's obvious that there's no gunpowder inside. The primer has been removed so that it can't be fired, so it makes it obvious that it's a dummy round.
And I'm going to stop you real quick. I want you to explain to the ladies and gentlemen of the jury what you mean when you say primer.
The primer is the base of the round, so it's the small circle that the firing pin hits. So since that's removed, there's nothing there for the firing pin to hit and project that projectile. The dummy rounds are also indicated by, if you shake them, they make a rattle sound. Instead of having gunpowder inside, they have ball bearings inside, so that you can shake them and know that they're not live ammunition.
So you just kind of went through some of the distinguishing characteristics of dummy rounds. Would a dummy round have all three of those distinguishing characteristics?
No, it could have 2 out of the 3, but I haven't run into any that have had all 3.
So approximately how many dummy rounds did you end up taking into evidence?
Specifically that were dummy rounds, I think we have 50. I might be mistaken about that. I apologize. I'm not sure of the exact number of dummy rounds that we have.
And let me just ask you this. You talked about how a round may have a ball bearing in it. Is that right?
Correct.
Would that dummy round that has the ball bearing in it, would that also have a hole in the side?
No, because then the ball bearings would fall out.
Okay. So do the dummy rounds either have a hole in the side or a ball bearing?
Correct.
And based on your work on this case, how would someone know that the dummy round with the ball bearing in it is actually inert?
They would shake it and it would make a rattle noise.
Okay. And did many of the dummy rounds that you took to the sheriff's department make those noises?
Yes.
Now, there was a question that came up in this channel's live stream chat about why the prosecution is even going over this, when it has nothing to do with whether or not Alec Baldwin was reckless or criminally negligent while on set. And I agree, this has absolutely nothing to do with that. But there are a few reasons why the prosecution wants to go over this nonetheless. First, they need the jury to understand what went wrong on set, just so that they can understand how Alec Baldwin even fits into that storyline. And that is, at the simplest explanation, that someone on set didn't do what they should have to distinguish between a dummy round and a live round. So in order to do that, the jury has to learn about how this wrong occurred and how it could have been prevented, at least on a very basic level. And so it's really helpful to understand how actually anyone can learn pretty quickly how to distinguish between a dummy and a blank and a live round, and that you don't have to be a firearms expert to do it. And this also goes into another reason that the prosecution likely wants this in, which is that they want the jury to walk away with the idea that preventing this tragedy was actually fairly easy, even with Alec Baldwin involved, and that it doesn't necessarily require all that much expertise. So this also could cut against the defense's argument that there has to be this delineation between people on set who work on safety and then those who work on art. Anyway, finally, the most basic reason for why they would want to spend time on this is because the prosecution does have the burden of proof here. And so they still have to put on a full case, not just the parts of the case that are related to where the real controversy exists between the two sides. They still have to show that a proper investigation was done and that they looked into all possible reasonable routes for culpability and that they are presenting to the jury a full and proper case. And so far, I do think that Ms. Poppell's testimony has been very helpful to that end. Now, she did not finish her direct examination on day 1, and so we'll have to see on day 2 what else they get into. And as always, we want to hold some space for the cross-examination because very often that is where the rubber meets the road, so to speak. So we will see how well her testimony holds up on day 2. But for my part, at this point, I really don't know where this trial is going to go yet. And a lot of that has to do with the fact that it seems to me that this trial is going to come down a little bit less to the actual evidence and forensics and whatnot, and a little bit more with the question of whether actors on movie sets, and whether Alec Baldwin in this case in particular, should be held to a different standard than most people are familiar with under the normal circumstances involving firearms. And I could honestly see this going either way at this point. But those are my thoughts. What do you think? Should there be a different standard for movie sets because of the requirements of the magic of movie making, so to speak? Or do even artists on movie sets still bear some responsibility for safety when they're involved in situations that still bring in some risk? Let us know your thoughts in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of the Alec Baldwin trial, both in daily recaps and in gavel to gavel live stream coverage, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. I will say that we are just below 250,000 subscribers, and I would love to see us hit that benchmark during this trial. So if you want to be a part of that, definitely hit the subscribe button. And if you really want to support the content, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon, and doing so means that over the long term of this channel, we can continue to devote intensive resources to trials like this one and other interesting legal topics. Links to both are in the description below. Otherwise, I'll see you on day 2.